In fashioning a fair and appropriate sentence, as I'm required, I'm looking at the gravity of this offense, the defendant's character, the need to protect the public, along with things like punishment, deterrence, rehabilitation. And all of those things are factors in this case, and factors for my sentencing. First of all, I want to say that, and I've told the lawyers this previously, and I think I put it on the record previously, but though he was an attorney, I did not know Mr. Clearman. He did not practice in front of me. By all accounts, the letters, the victim's wife, everything that's been presented certainly appears that Mr. Clearman was an upstanding citizen, but I did not know him. You know, the state referenced this, and I'm going to pick up one of the state's comments. This trial had a lot of noise around it, outside noise, antics from people not involved in this case. But this case was about the actions of the defendant. It was about the actions that occurred between two men in September of 2020. And I think it's incumbent upon me to say that a justice system that is constantly berated in certain segments of society is sometimes berated unfairly. This is a case where the justice system worked. The defense will recall, and the state will recall, there were actually two juries impaneled in this case. The first jury I dumped for various reasons that don't need to be discussed. The jury that eventually heard this case was the most diverse jury that I've ever seated in Milwaukee County. 6 people of color, 6 whites, including 5 African Americans. That jury, who truly was a jury of the defendant's peers, found the defendant guilty in about 2 hours. The jury decided this was not self-defense. This was a homicide. The defendant is being sentenced for a homicide. There's a lot to discuss related to this case and related to the defendant and the defendant's character, the defendant's actions, the need to protect the public, punishment, and other factors. But first of all, again, as the state mentioned, this case is part of the insanity that goes on in Milwaukee County with guns. And just so we're clear, Mr. Edgecomb is being sentenced only for his actions, not the actions of any other person or any other case. But as the state pointed out, and the state has heard me say this more than once on the record, homicides in Milwaukee County are out of control. In 2019, there were about 90. Then we almost doubled that in 2020. Then we increased it again in 2021. And though it's only early April, we're on pace to potentially double that homicide rate now to 400. And most of it is idiocy over arguments when people pull out guns. The state used this in their closing argument, and it's correct. Mr. Edgecomb brought a gun to a fist fight. Certainly, I saw the video, as the state said, 10 times, 20 times. I can't remember how many times. There was some, depending on how you believe, or which side you believe. There was some, not exactly a confrontation, but either the Clearman's vehicle swerved or Mr. Edgecomb cut in front of him, or there may have been some contact between the car and the bicycle that Mr. Edgecomb was on. That was not caught on video. Then there was the confrontation where Mr. Edgecomb bikes west on Brady Street at a very fast clip. The Clearmans are waiting in traffic. It's a short confrontation, but Mr. Edgecomb slugs Mr. Clearman through the car door window, hits him pretty much, certainly in a violent fashion. Then Mr. Edgecomb peels off, turns right, and heads up the bridge on Holton Street. I'm sure that Mr. Clearman was frustrated and upset that he'd just been punched by Mr. Edgecomb. And I'm sure that the victim's wife probably, I'm sure, questions why she turned and followed Mr. Edgecomb, even if that was what Mr. Clearman asked her to do. But to respond to the defense inference, I'm not going to be in a position here where I'm blaming the victim, or I'm blaming the person who was shot to death. Because that's along the lines of, well, don't drive on Capitol Drive because it's a war zone, because people drive so badly on that street that it's not safe. Don't go into a certain neighborhood because you might get shot. Don't approach someone, I would say he was striding quickly at Mr. Edgecomb, because he might have a gun. In a community that did not feel obligated or for some reason compelled to resolve arguments and fistfights with a gun, those kind of dangers would not be present. And this situation would have been resolved differently. Looking at the defendant's character, yes, I read there were probably at least a dozen letters on behalf of the victim, probably a dozen letters or more on behalf of the defendant. I read those letters. I read the pre-sentence investigation. I read the sentencing memorandum, which was only a few pages, that was submitted by defense counsel within the last day or two. Certainly, as the state conceded, Mr. Edgecomb is nowhere near the worst of the worst. I see defendants with far longer records, with much worse behavior, with far more dangerous behavior. This case did not involve, for instance, Mr. Edgecomb, as the defense pointed out, being in a gang or as part of an armed robbery or as part of some other form of violence. But as the state pointed out, well, Mr. Edgecomb's record is relatively limited, fairly limited. It has in the past involved allegations of, and at least one conviction of carrying a concealed weapon. And Mr. Edgecomb, you were not to be possessing a weapon when this occurred. Had you followed the judge or commissioner's order to not have a weapon on you, this resolves as a fist fight. And Mr. Edgecomb, there's only so much credibility I can give to your statements, and the jury rejected it completely, but your statements that you feared for your life. This, even if you attribute the worst motives to Mr. Clearman, and I'm not, but for the sake of the argument, the worst case scenario here should be a fist fight. You're 20 years younger than the victim. As the state pointed out, Mr. Clearman did not have a gun. He had a small switchblade that was in his pocket that he never brought out, that he never brandished, based on all the evidence and all accounts. And the defense said, well, this was sort of a random situation, which, depending on how you look at it, that could be mitigating or it could be an aggravating circumstance. Had the Clearmans stayed where they were for another 10 or 15 minutes at the restaurant or bar, had Mr. Edgecomb decided to go to a different restaurant that was not on Brady Street, this confrontation almost certainly never occurs, and Mr. Edgecomb would be going on with his life, but so would Mr. Clearman. And Mr. Edgecomb, no matter how difficult this is for you and your family, no matter what the sentence is, you killed another person. And your testimony, which the jury clearly rejected, and the jury made their decision that this was not self-defense, was not particularly credible. To say that, and you said it repeatedly on the stand, the gun just went off, when what the testimony was from multiple eyewitnesses was that you pulled up your hand and went like this, right at the forehead of the victim, and shot the victim almost directly between the eyes. That's not an accident. That's not a gun just going off. That's you brandishing a weapon and pointing it at someone's temple. Obviously, the defendant has a right to a trial. He exercised his right to a trial. The jury made a decision. But Mr. Edgecomb, you engaged in incredibly bad decision-making. You did not need to pull out a gun, and you certainly did not need to pull the trigger. While there was discrepancies in the testimony, there were, as I recall, 4 witnesses, not including the victim's wife. The 4 witnesses, one person was driving by, one person was behind the Clearman's vehicle. There were the 2 gentlemen sort of across the street or on the other corner. And everyone basically agreed there were some discrepancies, that the car pulls over, that Mr. Clearman gets out of the car. He starts, I would say, striding towards you. And you immediately pull out a gun, point it right at the victim, and the victim goes straight down dead. The whole thing happens in a matter of 2 or 3 seconds. I'm not sure, Mr. Edgecomb, that you understand the depths and the gravity of your offense. Mrs. Clearman's life and the life of her children will never be the same. There will never be a day that goes by that they don't think about this situation. I'm sure that, as Ms. Clearman said, it's bad enough to find out that a relative died, or a relative had a heart attack, or to be told to have a police officer come to your door and say that a friend or relative, or God forbid, a spouse was killed. But to watch your spouse be killed right in front of you when you're 10 or 20 feet away, I can't think of anything worse. And while, as the state pointed out, Mr. Edgecomb, your record's not the worst. You know, you're employed for the most part. You have an education. You were, it appears, supporting your children. You did a number of things in this case that aggravated the circumstances, aggravated the case both literally and figuratively. You claimed basically that this was self-defense. Yet, rather than staying on the scene or turning yourself in, you go on the run for 6 or 7 months. You leave the state, you allegedly ditch the gun somewhere in Indiana. You get picked up 6 or 7 months later in Kentucky. There's never been any acceptance of responsibility for your actions, Mr. Edgecomb. None. It struck me as I read the letters from both sides, and again, there were numerous letters on behalf of the victim describing Mr. Clearman and numerous letters on behalf of Mr. Edgecomb, that the two people involved in this tragedy have family members and friends that think very similar things about them. As I said, Mr. Clearman was clearly, based on the letters and his career, a fine, upstanding citizen. The letters all indicate that he was a good father, a good parent, a good spouse, a law-abiding citizen. The letters that were written on your behalf, Mr. Edgecomb, also are similar. Most of them say that you're a good father, that you've provided for your children, that you've got an education. And yet, because of a terrible, terrible, callous, thoughtless decision, we have someone who's killed in his mid-50s. And the state's correct. This is another case of people having no impulse control. I have other pending cases in front of me where, for example, in a bar, one guy bumps into a guy's brother. The brother pulls out his gun, starts firing up, shooting up the entire restaurant, the entire bar. One person's killed, another one's injured. I had a case that went to trial where the defendant's mad because somebody else allegedly pushes his ex-girlfriend. He decides to drive by the house and shoot and kill him. People have no impulse control in this community. And Mr. Edgecomb, had you not been violating the law and the order to not have a gun, then worst case scenario, this goes down as a fist fight. Broken nose, broken eye, someone's glasses get knocked off. The state discussed the defendant's not just record, but his multiple contacts with the criminal justice system. I'm giving that limited weight because it is a limited record, because it's outweighed for the most part by other characteristics from the defendant in terms of his prior record or lack thereof. The pre-sentence investigation basically says, I'm paraphrasing, that the defendant's sort of a moderate risk to the community, a moderate risk to reoffend. Certainly the defendant does need to be punished. He needs to be sentenced. You know, this is obviously a criminal, strike that, obviously a prison case. There needs to be deterrence, both specific deterrence to Mr. Edgecomb and general deterrence to the community. That it's time for people to stop resolving arguments or confrontations or any possible disruption in their life with a gun. Not just brandishing it, but firing it. And Mr. Edgecomb, again, all 4 witnesses that were independent to this case and the victim's wife all said that you pretty much immediately, as Mr. Clearman came at you, pulled the gun up, pointed it at him, and killed him. You shot him right here, almost right between the eyes. That is not an accident, as you testified. It's not. That's not the gun just going off. That's completely incredible, completely unbelievable. And I'm sure that's what the jury was thinking. I certainly understand the victim's family and their request for the maximum sentence on the first-degree reckless homicide, which the defendant was found guilty of. As the state said, and as I'm sure they've explained to the victim's family, this is not a maximum case. Maximum cases are, as the state noted, reserved for, frankly, the worst of the worst. It'd be someone who has a far longer record than Mr. Edgecomb, committed a homicide in a worse fashion, all sorts of other aggravating factors that aren't present here. But again, the jury of the defendant's peers determined that this was not self-defense. They did not deliberate for a long period of time, 2 hours, 2.5 max. I mean, Mr. Edgecomb, one of your family members mentioned explaining to your children why you're not coming back or why you weren't bailed out. That's nothing compared to having young adults or older children never see their father again, to have a father never be there for a wedding or graduation from college or purchase of a first home. Any explanation that has to be given to your kids is nothing by comparison. A, because you're still here, and B, because you engaged in this behavior. part of this sentence, frankly, is punishment. A lot of it is punishment and deterrence. You know, a civil society can't allow people to brandish weapons and shoot other people in the head. One would think that goes without saying, but with the crime in this community, that message has not gotten through to large segments of Milwaukee and Milwaukee County. Every sentence that occurs in a homicide, let alone any other case, also needs to be proportionate to what other similar cases and other similar situations receive. Every case is unique, obviously. Every set of circumstances is different from one case to another, including from one homicide to another. I'm certainly aware of all the requirements of Galleon and similar case law regarding what's necessary in terms of punishment, regarding what's necessary in terms of confinement. And candidly, the request from the defense is not appropriate. The request from the state is candidly lower than I expected it to be. And for anyone that doubts that, within the last 10 days, I had a case that was very, very similar, where a defendant alleged self-defense. The jury did not believe it. That defendant testified, did not testify truthfully. And in that case, the state asked for over 30 years. So the state's recommendation in this case is on the low end of what would be recommended in a homicide similar to this. That's just reality. The one thing the state did not discuss is obviously there was the aspect of provocation in this case. Mr. Edgecomb, I don't know what was going through your head. Whatever happened initially, and I don't believe the testimony or the implication that you were hit by the Clearman's car and you rolled up on their side of the car or the front of the car, that's not plausible because your bike was not damaged, you weren't injured, there was no visible damage to the car. That's not plausible. But whatever did occur, for you to be so hot under the collar that rather than ignore it or drive by and handle it in some other fashion, you slug through a window and do significant damage to the victim, punching him in the face and in the eye and knocking his glasses off, causing abrasions and cuts. I can't imagine what was going through your head and why you thought that was an appropriate way to respond to whatever happened initially that was not caught on camera. And then again, ultimately, Mr. Edgecomb, there was no need whatsoever, even if, and yes, Mr. Clearman was striding towards you, for you to pull a gun and within a matter of a couple of seconds, put a bullet in his skull. I apologize if that's a very candid description of what occurred, but that's what occurred. Having said that, I'm sentencing the defendant as follows, largely following the state's recommendation: 25 years of initial confinement, 12 years of extended supervision. That's on count one. That is the absolute minimum required to punish the defendant, to incarcerate him, to send a deterrent message to this community. 25 years of initial confinement, 12 years of extended supervision. This was a homicide. That sentence is consecutive to the end of the case, consecutive to any other sentence. And count 2, which is the bail jumping, sentencing the defendant to a total of 4 years, 2 years of initial confinement, 2 years of extended supervision. That sentence is concurrent to count 1, concurrent to count 3, and concurrent to any other sentence. And count 3, which is the misdemeanor bail jumping, I'm sentencing the defendant to 6 months in the House of Corrections or in jail. That sentence is concurrent to count 2 and concurrent to count 1. It's the court's specific intent that the defendant serves 25 years of initial confinement, 12 years of extended supervision. In this case, the defendant is not eligible for the challenge incarceration program, not eligible for the substance abuse program. The defendant will be provided a written explanation of the determinant sentence. While in the institution, I'm authorizing up to the maximum amount be taken out of the defendant's in-custody earnings, wages, funds, or monies of any sort. I'm granting the state's request for restitution, which was stipulated to. The restitution amount is $4,840. The restitution is to be paid to the victim's wife. Conditions of extended supervision are as follows. First of all, because this matter is a felony, Mr. Edgecomb is not allowed to own or possess a firearm, a gun, at any time ever for the rest of his life. He's not allowed to vote in any elections until civil rights are restored. They will be restored at some time in the future, but until then, you're not allowed to vote. Mr. Edgecomb, you will have the right to appeal. An appeal would have to be filed within 20 days. Conditions of extended supervision are as follows. First of all, no further law violations rising to the level of probable cause. Mr. Edgecomb is not allowed to own or possess a gun or a weapon of any kind. Mr. Edgecomb, when you're released, you are obligated to work full-time. You're to pay restitution if it's not already been paid while you're in the institution. I'm ordering the defendant to pay all costs, fees, and surcharges, both mandatory and non-mandatory costs, fees, and surcharges. They're to be paid first while in the institution, then if not paid while in the institution, paid while on extended supervision. While on extended supervision or while in the institution, I want the defendant to have an AODA assessment for any drug or alcohol needs. If there are any AODA needs, he's to be treated in the institution or while on extended supervision. While on extended supervision, Mr. Edgecomb is not allowed, strike that, I'm ordering absolute sobriety. Mr. Edgecomb is not allowed to drink alcohol. He's not allowed to use any illegal drugs. Beyond those conditions, I'm going to leave the further conditions of extended supervision up to the Department of Corrections. Again, in this case, because of the nature of this offense, the defendant is not eligible for the challenge incarceration program and not eligible for the substance abuse program. I will provide the defendant with a written explanation of the sentence in this case. Again, the defendant has a right to appeal. An appeal would have to be filed within 20 days. I'll ask the state, am I forgetting anything? Did I leave anything out?
No.
Defense?
No, Your Honor.
All right, then we're adjourned. We're off the record. Thank you.